Hi, in this video, I'm going to show you why the form of the power of attorney is important. And I'm going to explain and show you how the law asks us to do some specific things when we sign powers of attorneys. In consultations, one of the first things that I ask clients is, do you have estate planning documents? And one of those estate planning documents is the durable power of attorney. The durable power of attorney, as I explained in prior videos, is the document through which we do our job. So we don't try not to bother the person who is incapacitated or in, let's say, in a nursing home or in a hospital or at home. So we use the power of attorney to do everything that we need to do. But again, in order for that power of attorney to be effective, it needs to follow whatever the law says. And Florida is very specific as to certain powers, what we call in our practice the superpowers. And the superpowers we call to the powers that are very important and that the law asks us to discuss in detail with the client. So I'm going to refer to this statute here, 709-2202, authority that requires separate enumeration. And basically what this statute says is that in order for the principal to delegate important powers to an agent, the principal must initial next to each specific enumeration of the authority. So what are those? Are these here. So basically what the statute and what the law asks us to do is that whenever you want to create an inter vivos trust, or whenever you want to amend, modify, or revoke or terminate a trust, or whenever you want to make a gift, or whenever you want to create or change a right of survivorship, or whenever you want to create or change a beneficiary designation, or you want to waive the principal right to be a beneficiary of an annuity, or disclaim property and powers of appointment, the law wants us to discuss that with the client in detail, and then the client can say yes or no by initialing next to each power. So how does that work in practice? So let's say a client comes to me and I tell the client, look, do you want to include in your power of attorney the power for your agent to create an inter vivos trust? And the client will ask me, so what is that? So basically, if you need a trust, you are authorizing your agent to create one. And I discuss with the client the pros and cons of that. And let's say the client say, yes, I do want to do that. So basically what the client needs to do is initial. So let's say it's me. So I initial next to that particular power, and so on and so forth. So I discuss whether you want to include in the power to amend, modify, revoke, or terminate a trust. So I discuss with the client the pros and cons, and if the client is agreeable, then I will tell the client, okay, initial next to that particular power. So here, if you want to make a gift, so if you want the client to authorize the agent to make a gift, then I discuss with the client the pros and cons, and then if the client is agreeable, then it's going to initial next to that particular power. So that's what Florida law says. Again, the law says if the principal sign on initial next to each specific enumeration of authority. So it's very specific, next to each specific enumeration of authority. So, and in our practice, what we see is the following. Clients come to us with powers of attorneys prepared by attorneys, and this is one of them. This is a form that I came across in my practice. It's a Florida General Durable Power of Attorney. So basically, the way that this power of attorney was prepared is that every single authority was included, and an option to initial next to each one. So you have real property transactions, and then you were able to initial here. So let's say I wanted to initial, so basically what I do is just put my initial here next to this one, so on and so forth. Tangible personal property transactions, stocks and bond transactions, commodity and option, and so on and so forth. But here's the problem with this power of attorney. At the end of the power of attorney, we have this particular language. All of the power listed above. This is not what Florida law says. Again, Florida law is very specific, and it says next to each specific enumeration of authority. And it doesn't include every single power. It doesn't include real estate transaction. It doesn't include stock and bonds. It only includes these particular ones here: inter vivos trust, amend, modify, or revoke a trust, make a gift, create or change right of survivorships, and create and change beneficiary designation, and so on and so forth. There are, like 7 here. So this particular one, which I think this one they use a lot in New York. This is like the New York model. But again, when you see this in your power of attorney, all of the power listed above, and you initial here as if I want this power, by initialing here, I will include all of this power here. This is not valid under Florida law. So review your power of attorney. If your power of attorney is like this, then you gotta do a new one. So this is not good. Here's the other example of powers of attorney that we usually don't like. This is a form that I just searched on Google, Florida powers of attorney, and this is the form that I got. And here it is. It says, it's a power of attorney, and it enumerates the powers here: payment powers, safe deposit boxes, banking powers, all that kind of stuff. And it doesn't have any powers or any reference to the superpowers. So no superpowers are included here. Okay, so it says trust powers, but again, Florida law says that you have to initial it, right? Create an inter vivos trust, or amend or modify or revoke a trust. So here in this one, it doesn't have an initial. Here's the other problem here: general powers. This language in Florida doesn't work to do all other acts, deeds, matters, and things whatsoever, to concur, whatever. So this general language here doesn't work in Florida. So you have to be very specific. So this is another power of attorney that we see all the time, and we tell our clients, I'm sorry, this is not valid. So we can't have this power of attorney. We cannot do our job with this power of attorney. So let me give you an example of what we do with powers of attorney, so I'll give you an idea of what is it that we prefer with powers of attorney. Let me just get to that particular. Okay, here it is. This is something that we prepare in our practice a lot, and I'm going to show you how we do it so you have an idea. We list each what is called superpower, so the power to create trust, and we have here a box for initials, and we specify which type of trust we are authorizing for the principal. So a self-settled specialist trust, trust for Medicaid, trust for any other type of Medicaid qualification. We include all the annuities. We are specific about the gifting powers. And here is our magic language about estate and long-term care planning. So we include all these particular powers here: Medicaid application, filings of Medicaid application, and things like that. So very important. We have to be very specific with the superpowers. So that's kind of what I wanted to go over in terms of forms. So if your form, again, is one of this one, either this one that doesn't include any superpowers and no initial, or this one that includes all of the power listed above, as if you can initial in this one and all of the above are included, is not good. Another particular issues about powers of attorney is again, what the statute says when a power of attorney terminates. So here's what the statute says. When the principal becomes incapacitated if the power of attorney is not durable. So again, for a power of attorney to continue, if you are incapacitated, you gotta make it durable. And to make it durable, you gotta include these words. This durable power of attorney is not terminated by subsequent incapacity of the principal, except as provided for in Chapter 709 Florida Statute. So you have to include this language in the power of attorney. And again, here is the statute that says that when the power of attorney is effective when the power is executed. So the powers of attorney is effective when executed. So you don't need, or you don't, in the past, and here's what the statute says about powers of attorney executed before October 1st, 2011, that you needed the letters of a physician to make it effective. So we don't have those anymore. If you sign the power of attorney after October 1st, 2011, the power of attorney is effective when executed. So those are my points about powers of attorney. Be very careful. You have to think about the superpowers and how the superpowers need to follow the formalities of law. Otherwise, it's not going to be valid. And if it's not going to be valid, we need to re-execute the power of attorney. And sometimes when it's time to re-execute the power of attorney, the person who needs to sign doesn't have capacity anymore, and that becomes a problem. Why? Because we need to do guardianship, and that's what we don't want. Again, check your power of attorney, make sure it follows what I just said, and that will prevent a lot of headaches. Thank you very much, and I will see you in the next video.